If you've read or watched any of my blogs and vlogs on catastrophic impairment law, then you know that if you sustain injuries from an accident that meets specific criteria, you may apply for a catastrophic impairment designation to increase your policy limits to $1 million. But what if you weren't involved in an accident? What if you suffered psychological and emotional or mental injuries as a result of your wife, husband, or child's catastrophic accident, and you didn't even witness the accident? Can you, a person not actually involved in the accident and who didn't witness the accident, apply for and meet the criteria of a catastrophic impairment as defined by the SABs? In this episode, I'll answer this question and much more. Stay tuned. Hi, and welcome to the fourth episode of season 2 of my vlog, Personal Injury Lawyer Tips. My name is Angie Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual Solo and Small Firm Conference, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing whether or not a person not involved in an accident can meet the criteria for a catastrophic impairment as defined by the Ontario Regulation 34/10 Statutory Accident Benefits Schedule, or the SABs for short. I'm going to first discuss a recent license appeal decision entitled Kellerman-Bernard and Unica Insurance Company, where the adjudicator initially rejected this notion. I'll then discuss the recent divisional court's decision to overturn the LAT's decision and ultimately rule in favor of a person not involved in an accident to meet the criteria for a catastrophic impairment designation. By way of background, the applicant, Ms. Naomi Kellerman-Bernard, sustained psychological and emotional injuries and impairments caused by a bicycle accident in which her son was significantly injured on January 26, 2016. Ms. Kellerman-Bernard was not involved in the bicycle accident with her son, nor did she see the tragic bicycle accident. But on February 2, 2016, she applied for accident benefits to the respondent, Unica Insurance Company, pursuant to the SABs, including an application for determination of catastrophic impairment to the insurer on October 24, 2018. Ms. Kellerman-Bernard's claim was denied, which prompted her to appeal the denial to the License Appeal Tribunal Automobile Accident Benefits Service on February 10, 2020, for dispute resolution. The indisputable facts of the case were as follows. 1. The applicant's child was involved in the accident. 2. The applicant did not witness the accident. And 3. The applicant claimed accident benefits because of psychological and emotional or mental injuries she allegedly suffered as a result of her child's bicycle accident. So the issue before the adjudicator at the License Appeal Tribunal was, can an applicant not involved in an accident meet the criteria for a catastrophic impairment as defined by the SABs? The respondent, Unica Insurance Company, didn't dispute that Ms. Kellerman-Bernard was an insured person under the automobile insurance policy and was eligible to claim accident benefits. They disputed that she was not entitled to apply for a catastrophic impairment designation because she was not involved in the accident, and therefore her injuries weren't caused by the accident as defined in the SABs. as she does not meet the criteria for a catastrophic impairment designation in the SABs. The respondent also submitted that this was a novel issue and there was no legal precedent factually on point. Counsel for Ms. Kellerman-Bernard argued that she is an insured person under the SABs who sustained psychological and emotional or mental injuries caused by the accident, for which she is eligible to apply for a catastrophic impairment designation. They submitted that there is no difference to Ms. Kellerman-Bernard's injuries being caused by an accident or as a result of an accident, and that furthermore, there is no requirement in the SABs for an insured person to have been involved directly in an accident to apply for a catastrophic impairment designation. So both parties agreed that Ms. Kellerman-Bernard met the definition of insured person under the SABs. However, the adjudicator stated that this fact was not determinative of the real issue, which is whether Ms. Kellerman-Bernard can claim a catastrophic impairment designation. The adjudicator in this case ultimately found that Ms. Kellerman-Bernard did not meet the criteria for a catastrophic impairment determination as defined by the SABs, because her psychological and emotional or mental injuries were not caused by an accident as required by the SABs. The accident took place on January 26, 2016. So the version of the SABs for the period from August 26, 2015 to March 3, 2016 applied, where Section 3 Sub 2 of the SABs defines catastrophic impairment as follows, quote, "For the purposes of this regulation, a catastrophic impairment caused by an accident is," end quote, and then followed by a list of 6 categories of physical, brain, mental, and behavioral impairments. So under Section 3 Sub 2 of the SABs, the adjudicator stated that the catastrophic impairment designation requires a 2-part test to be met as follows. 1. The threshold test is that the applicant, Ms. Kellerman-Bernard, must establish that her injuries are caused by an accident. And if this threshold test is met, then 2, Ms. Kellerman-Bernard must then establish that her injuries fit within at least one of the listed categories of impairment. The adjudicator agreed with the respondent's argument that the phrase "caused by an accident" was purposely used in the SABs to restrict entitlement to a catastrophic impairment designation to persons who directly suffer injuries caused by an accident, because the legislature chose to treat access to enhanced catastrophic impairment benefits more restrictively. The adjudicator then applied the principles of statutory interpretation as outlined by the courts, including the Supreme Court of Canada, to the interpretation of Section 3 Sub 2 of the SABs. In interpreting the meaning of the phrase "caused by an accident," the adjudicator applied the modern approach to statutory interpretation, which involves a textual, contextual, and purposive analysis, as well as a consideration of the following 3 factors. 1. The language of the provision. 2. The context in which the language is used. And 3. The purpose of the legislation or statutory scheme in which the language is found. The adjudicator found that the phrase "caused by an accident" was clear and is not ambiguous, particularly when considered in the context in which the language is used. The adjudicator noted that the word "accident" is defined in the SABs as an incident in which the use or operation of an automobile directly causes an impairment. The adjudicator went on to state that, in regards to interpreting the term "accident" itself, the law is well settled that if it can be established that the use or operation of an automobile was the cause of the injuries, then the applicant must establish that there was no intervening acts that resulted in the injuries that cannot be said to be part of the course of the ordinary course of things. The determinative question for the adjudicator was whether it can be said that the use or operation of the automobile was a direct cause of the injuries. From the adjudicator's perspective, direct causation requires a determination of the dominant factor that physically caused the applicant's injuries. At a minimum, the adjudicator stated that some direct physical connection is required between the insured person's injuries and an automobile for the injuries to have resulted from an accident. If not, then the adjudicator concluded that the insured person's alleged injuries cannot be said to have been caused by an accident. As such, the adjudicator concluded that Ms. Kellerman-Bernard's psychological and emotional or mental injuries were not directly caused by an automobile because she did not witness her child's accident. The adjudicator thought that his purpose of interpretation of the phrase caused by an accident was consistent with the fact that the legislature has seen fit to restrict access to the highest level of accident benefits available under the SABs to those insured persons who suffer a catastrophic level of injury directly caused by an automobile. So again, since Ms. Kellerman-Bernard did not witness the accident and was not directly involved in the accident, the adjudicator concluded that she was unable to meet the threshold test for a catastrophic impairment designation required by Section 3, Sub 2 of the SABs. As a result, the adjudicator concluded that Ms. Kellerman-Bernard cannot and did not meet the second part of the catastrophic impairment test. The adjudicator took his purpose of interpretation of the phrase caused by an accident a step further when he stated that he was of the view that the legislature used this phrase purposely and in order to restrict a catastrophic impairment designation to the most seriously injured directly by the use or operation of an automobile and not to their more indirectly affected family members. So on February 3rd, 2022, the LAT decided that Ms. Kellerman-Bernard was not entitled to apply for a catastrophic impairment designation, as she did not belong to the class of insured persons that was entitled to seek such a designation. Ms. Kellerman-Bernard requested that the LAT reconsider its original decision, and on May 22, 2022, the LAT denied her request for reconsideration. So Ms. Kellerman-Bernard appealed both LAT decisions to the divisional court. Since her appeal concerned a question of law alone, where the question is one of statutory interpretation, the applicable standard of review was correctness. So let's now focus on the appeal to the divisional court, beginning with the relevant statutory framework. The appeal in the case at bar involved the interplay between three provisions in the SABs, which were as follows. 1. Section 3 Sub 1, which defines who is an insured person. 2. Section 45 Sub 1, which provides that an insured person is entitled to apply for a catastrophic impairment designation. And 3. Section 3 Sub 2, which sets out the criteria necessary to qualify for such a designation. Section 3.1 sets out two classes of people who are named in the policy who qualify as insured persons, as follows. 1. Named insureds who are actually involved in the accident. And 2. Named insureds who are not actually involved in the accident, but who suffer psychological and emotional or mental injuries as a result of the fact that their family member was involved in the accident. The appellant, Ms. Kellerman-Bernard, falls within the second class of insured persons. She is named in the policy. She was not directly involved in the accident, but she suffered psychological and emotional or mental injuries as a result of the fact that her son was directly involved in the accident. In a 2016 case entitled Air Farmers Mutual Insurance Company and Wright, at paragraph 25, the Court of Appeal stated, quote, "It is well established that the definition of insured person in the SABs governs the entitlement to SABs," end quote. However, again, it was not contested between the parties that Ms. Kellerman-Bernard was an insured person. Section 45.1 confers upon an insured person the right to seek a catastrophic impairment designation. It reads as follows, quote, "An insured person who sustains an impairment as a result of an accident may apply to the insurer for determination of whether the impairment is a catastrophic impairment," end quote. Pursuant to this section, Ms. Kellerman-Bernard, an insured person, applied to Unica Insurance Company for a determination as to whether her impairment was a catastrophic impairment. The insured denied her application on the basis that she did not fall within the class of insured persons that was entitled to apply for a catastrophic impairment designation. The LAT agreed with the insurer. Again, it did so on the basis of its interpretation of Section 3 sub 2 of the SABS. Section 3 sub 2 of the SABS defines catastrophic impairment as follows, quote, "For the purpose of this regulation, a catastrophic impairment caused by an accident is," end quote. And then it's followed by a list of 6 categories of physical, brain, mental, and behavioral impairments. The divisional court noted that the LAT, in its 2 decisions, focused on the phrase "caused by an accident" in Section 3 sub 2 of the SABS and found that Ms. Kellerman-Bernard was not entitled to apply for a catastrophic impairment designation because she was not directly involved in the accident and thus her impairment was not caused by an accident. Thus again, the LAT found that the class of insured persons to which Ms. Kellerman-Bernard belongs, namely people who are not themselves involved in the accident but who suffer psychological and emotional or mental injuries as a result of an accident that resulted in an injury to their family member, are not entitled to seek a catastrophic impairment designation. The divisional court overruled the 2 LAT decisions and as such allowed Ms. Kellerman-Bernard's appeal. Why? In summary, the divisional court allowed the appeal because of the following 3 errors of law committed by the LAT, which are as follows. 1. The LAT ignored the plain language of the SABS. 2. The LAT failed to consider the words "caused by an accident" in their entire relevant context. And 3. The interpretation adopted by the LAT ignored the purpose of the SABS. I'll now go into each of the 3 errors of law in more detail. The divisional court noted that the first error of law committed by the LAT was that it ignored the plain language of the SABS. In a 2018 case entitled Skunk and Katash, the Court of Appeals stated the following, quote, "The principles of statutory interpretation require the court first to look to the plain meaning of the statute. If the words have a plain meaning and give rise to no ambiguity, then the court should give effect to those words," end quote. In the case at bar, the LAT found that not all classes of insured persons could apply for a catastrophic impairment designation, which is contrary to the express language of Section 45 sub 1 of the SABS, which states that an insured person may apply for a catastrophic impairment designation. Section 45 sub 1 puts no restriction on who can apply for such a designation. In order to illustrate this point, the divisional court contrasted Section 45 sub 1 with Section 28 sub 2 of the SABS, which deals with entitlement to optional benefits. In Section 28 sub 2, the legislator specified through a list which class of insured person is entitled to apply for optional benefits. This constituted proof that when the legislature wants to restrict benefits to only certain people, it does so through explicit language. However, Section 45 sub 1 contains no such list, and as such, anyone who is an insured person is entitled to apply for a catastrophic impairment designation. The divisional court also noted that the decision of the LAT also ignored the plain meaning of Section 3 sub 2 of the SABS, which contains no language that speaks to the insured person's entitlement to apply for a catastrophic impairment designation. Rather, Section 3 sub 2 only sets out the functional and medical criteria to be used in assessing whether the impairment at issue can be considered catastrophic. As a result, the divisional court concluded that the LAT interpreted Section 3 sub 2 so as to restrict the application of Section 45 sub 1, where there is nothing in the express language of Section 3 sub 2 that supports such an interpretation. The divisional court noted that the second error of law committed by the LAT was that it failed to consider the words "caused by an accident" in their entire relevant context. In a 2019 case entitled Canada, Minister of Citizenship and Immigration, and Vavilov, the Supreme Court of Canada reiterated at paragraph 117 that the proper approach to statutory interpretation requires reading the language chosen by the legislature in its entire relevant context. The divisional court stated that the LAT failed to do this and instead took the phrase caused by an accident in section 3 sub 2 out of context, and then asked itself whether Ms. Kellerman-Bernard's impairment was caused by an accident within the meaning of case law that had no application to the case at bar. The case law that the LAT examined dealt with entitlement to benefits by people who were not clearly insured persons within the meaning of the legislation. By contrast, Ms. Kellerman-Bernard was an insured person, and as such, according to the express language of section 45 sub 1, her entitlement to apply for catastrophic impairment designation was clear. The divisional court noted that if the phrase had been considered by the LAT in the entire relevant context, it would have been clear that its purpose is not to restrict entitlement to apply for benefits under section 45 sub 1, but rather to clarify that the only impairments to be considered in assessing whether the impairments at issue are catastrophic are the impairments that were caused by the accident, as opposed to other causes. As such, there is no issue that Ms. Kellerman-Bernard suffered psychological and emotional or mental injuries as a result of the accident. The only issue is whether that injury qualifies as a catastrophic impairment. The divisional court noted that the third and final error of law committed by the LAT was that the interpretation it adopted ignored the purpose of the SABs. The aforementioned 2019 case entitled Canada, Minister of Citizenship and Immigration, and Vavilov, the Supreme Court of Canada reiterated that the words of a statute are to be read, quote, in their entire context, in their grammatical and ordinary sense, harmoniously with the scheme of the Act, the object of the Act, and the intention of Parliament, end quote. The divisional court noted that the jurisprudence has repeatedly recognized that the SABs are remedial and constitute consumer protection legislation and ought to be read, interpreted, and applied in such a way. This, of course, was confirmed by the Supreme Court of Canada in a seminal 2002 case entitled Smith and Cooperators General Insurance Company at paragraph 11. In another 2019 case entitled Tomek and Economical, the Ontario Court of Appeal confirmed that, quote, the legislature's definition of catastrophic impairment is intended to foster fairness for victims of motor vehicle collisions by ensuring that accident victims with the most health needs have access to expanded medical and rehabilitation benefits. That definition is meant to be remedial and inclusive and not restrictive, end quote. And that the goal of the SABs, quote, is to reduce the economic dislocation and hardship of motor vehicle accident victims, and as such, assumes an importance which is both pressing and substantial, end quote. In light of the aforementioned case law, the divisional court concluded that the interpretation adopted by the LAT was restrictive instead of being remedial and inclusive. The divisional court added that instead of fostering fairness for people with the most health needs, the interpretation adopted by the LAT increases their suffering and economic hardship. For these reasons, the divisional court allowed the appeal, set aside the decision and reconsideration decision of the LAT, and found Ms. Kellerman-Bernard to be eligible to make a claim for a catastrophic impairment designation. It's important to remember that the divisional court's interpretation of the legislation was before the changes to the SABs on June 1st, 2016. So there may be attempts by insurers to challenge the decision with similar denials involving accidents that occurred after June 1st, 2016. Also, this decision may be appealed, so we'll have to wait and see. However, as of right now, this is a great, just, and fair decision for a small class of insured people who sustain catastrophic psychologically and emotional or mental injuries and impairments due to a loved one's injury and impairment as a result of an accident, as now they can proceed with an application for a catastrophic impairment designation. If you want to learn more about the criteria that you must satisfy in order to obtain a catastrophic impairment designation for a mental and behavioral disorder you sustained as a result of a motor vehicle accident in Ontario after June 1st, 2016, then please watch episode 1 of season 2 of my vlog called Catastrophic Impairment, Mental and Behavioral Disorder. I hope you found this information valuable. If you want more information, then please read my blog called Can a Person Not Involved in an Accident Meet the Criteria for a Catastrophic Impairment Designation? In my blog, I take a deep dive into this novel issue about whether or not an insured person not involved in an accident can apply for a determination of catastrophic impairment. I also provide links to other blogs such as What is a Catastrophic Impairment? And how does a guideline impact the determination of a catastrophic impairment, which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you. And I'll see you soon in the 5th episode of Season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.